What is IPRA Law? So the IPRA Law, or Indigenous People Rights Act of 1997, is a Philippine law officially known as Republic Act No. 8371. It was enacted to recognize, protect, and promote the rights of indigenous culture communities and indigenous people in the Philippines. So the IPRA has a set of rules that help indigenous communities like the Igorot or Lumad keep their lands, culture, and traditions safe. The law gives them the right to own their ancestral lands, maintain their cultural practices, and govern themselves according to their customs. First, we have the right to ancestral domains and land. So the indigenous people have the right to own and occupy ancestral land. So these lands are considered private and community. So imagine a community of indigenous people like the Lumad in Mindanao who have lived in the forested area for centuries. So they have the traditional hunting grounds, burial sites, and areas for farming. So the IPRA recognizes this land as their ancestral domain. This means they have the right to use and protect these lands for their cultural, economic, and social well-being. So for example, the Ifugao people in the Cordillera region are famous for their rice terraces. So these terraces are considered part of their ancestral domain. So they have the traditional practices for maintaining the terraces and ensuring their sustainability. So the IPRA protects these terraces from being destroyed or taken over by others. The right to ancestral domains and land under the Indigenous People Rights Act IPRA of 1997 in the Philippines allow indigenous people to own and occupy lands they have traditionally used for generations. So number 2, we have the right to cultural integrity. So the right to preserve and develop their cultural traditions and institution. So think of a cultural integrity as the freedom for a community to keep doing what they've always done. So like celebrating their festival, speaking their language, and practicing their tradition crafts. It's about being able to pass down customs and beliefs from one generation to the next. So for example, the Ifugao people known for their stunning rice terraces, so have traditional ceremonies like the Hapaw Rice Bear ceremony. So this event not only involves making rice bear but also includes rituals that honors their ancestry and the spirit of the land. By continuing this practice, they preserve their cultural identity and pass on their knowledge to younger generations. Number 3, we have the right to self-governance and empowerment. So IPs can maintain and develop their own political structure. Customary laws are recognized in settling internal disputes. So think of self-governance as a community being able to run its own affairs, much like a town having its own mayor and council to make decisions. So indigenous communities can create their own rules and structure to manage their people and resources, similar to how a family decide what work best for them. So for example, the Lumad communities of Mindanao, they have their own governance system where decisions are made collectively by council of elders. So for instance, if there's a disagreement about resource use, the elders will convene to discuss and find a solution based on their traditional practices, ensuring that everyone respects the community customs. Number 4, we have the right to social justice and human rights. Equal access to opportunities, basic services, and protection from discrimination. So this right means that indigenous people should have the same chances as everyone else to access education, healthcare, jobs, and other essential services. It also protects them from being treated unfairly because of their ethnicity or cultural background. In simple terms, it's about making sure that indigenous communities can live healthy, educated lives without facing discrimination. So for example, healthcare services. Health services should be available to indigenous communities without discrimination. For example, healthcare workers might conduct regular visits to Lumad communities in Mindanao to provide essential medical services and health education, ensuring that these communities can receive proper care. NCIP, National Commission on Indigenous People, tasked with implementing the IPRA law and issuing certificates of ancestral domain titled CEDT and certificates of ancestral land titled CELT. So imagine a community of indigenous people like the Lumad in Mindanao who have lived in a forested area for generations. They apply to the NCIP for a CEDT to efficiently officially recognized their rights over the entire forest where they gather food, hunt, and perform cultural rituals. By receiving the certificates, they can prevent outsiders such as logging companies from taking over their land. So additionally, if a family within the Lumad community wants to build a school on a specific plot of land within the forest, they can apply to a CELT. So this certificate would give them legal ownership of that specific area, allowing them to develop it for educational purposes while still being part of their ancestral domains. So, Indigenous People Rights Act IPRA, enacted in 1997, recognizes the ancestral domains and lands of indigenous people in the Philippines. However, it does not specify a set number of years that indigenous people must have owned or occupied the land to claim ownership under this law.
Notable Supreme Court cases in Indigenous People's Rights. First case, Cruz Bisig of Environmental and Natural Resources, which is challenge IPRA, questioning its conflict with government control over natural resources. The Supreme Court rejected the challenge, highlighting ongoing debate on balancing indigenous rights plans with state authority. So with these cases, the indigenous people questioning the conflict through government control over their natural resources, but at the same time, the Court Supreme rejected the challenge. They highlighting the ongoing debate on balancing indigenous land rights with their authority state right. Second case by Loloy Onduran v. Ramon Averastori. By the Supreme Court has ruled that land disposed in involvement indigenous communities are handled by the NCIP if are the same community. Otherwise, a regular court handles by this case. The Supreme Court ruled that the land disposed involved in the indigenous community are handled by the NCIP rather from the same community. In otherwise, the regular court handles the cases for the indigenous people's rights. The third case by Sama versus People. The Supreme Court upheld the Sama people land rights, fighting IPRA role in the correcting past injustice, empowering indigenous communities. Case Sama highlighting IPRA role in correcting past injustice by empowering indigenous people for their communities.
Here, the case of Carino v. Insular Government 1909. So, Mateo Carino was Ibaloy chieftain from Benguet Province, Luzon. His family had occupied a cultivated land in the area known as Kapagway and present day is Baguio City. For a generation long before the arrival of Spaniards and Americans during the Spanish colonial period, Mateo was recognized as the landholder, and the Spaniards even issued a title of recognition document affirming his ownership. When the Americans took over after Spanish-American War in 1898, the Philippines came under U.S. rule. The American colonial government began to classify land under new laws, mainly Act Number 496, also as the Land of Registration Act of 1903. Regarding to this act, only land officially registered with the government were recognized as private property. Also, the land were considered public domain because Mateo Carino did not have formal title registered under this law American system. His land was declared public land and was used in a part to build military reservation in Baguio. In 1904, Carino filed as a case against the insular government or the USA colonial administration in the Philippines to claim his land. The lower court in the Philippines ruled against him, saying he failed to prove ownership under the new legal requirements. So Carino applied to United States Supreme Court. As Supreme Court ruling 1909, the court reserved the Philippine decision and ruled in favor of Mateo Carino. Justice Oliver Wendell Holmes wrote the opinions stating, every position in the land ought to be a favor of the individual holdings title to the land. A principle of justice cannot be ignored simply because it is inconvenient to be colonial government. Holmes acknowledged that was in this case a person has long processed and used land such continuous occupation and care amount the rightful of ownership, even if no formal title was used. This ruling established what is now known as doctrine of native title, which means indigenous people own the land they have traditionally occupied and used even without formal land titles, as long as occupation existed before organization and has been continuous and recognized by their custom or tradition. The importance and legacy of this case is that Carino case is the one of the first recognition of indigenous land rights by a Western land system to pave the ways for legal recognition of essential domain and essential land. The creation of the Indigenous People Right Act IPRA of 1997, which formalized the right in Philippine law. The NICP or the National Commission of Indigenous People today, based on the part of its authority on principle established in the case. But even though Mateo won the case, much of the land was never returned to his family. The US government had already used or distributed part of the land. The land became part of Baguio City, which grew as a colonial hill station and later a major Philippine city. The law that involved this case are the Act 1996 People Land Registration Act required all owners to register land with the government. Unregistered land were declared public. Act number 1996 allowed that government to sell unregistered land and did not recognize essential domain unless proven by official title. And Philippine Organized Act of 1900 US Act number 1369 stated that all land not clearly privately owned would be the main public land. And the lesson from this case is that the rights of indigenous people are rooted not just document but in tradition, history, and as long as term or care of the land. Modern law must respect pre-colonial ownership system, and legal system should not erase native custom in favor of imposed structures. So here the case of Bacalso v. NICP 2007. So who are the Bacalsos? The Bacalso family, based in the Cebu, claimed that a piece of land was their ancestral land. They said the indigenous ancestor had lived on and cared for the land for a very long time, even before formal land laws existed. They wanted this land to be legally recognized as theirs. They applied for a certificate of ancestral land titled CLAT through the NICP National Commission of Indigenous Peoples. The NICP is a government agency created by Indigenous Peoples' Right Act IPRA of 1997 to protect the right of Indigenous peoples, including their essential lands. The NICP approved the application and gave them the CLT of official recognizing their ownership of the land. So the legal issue here is non-indigenous claimed other people who also claimed the land disagree with the NICP decision. They went to regular courts and agreeing that NICP had no power to decide land ownership. Only regular courts like trial courts should settle proper dispute. So the court decision. The Supreme Court ruled in favor of the NICP, said NICP has authorized to use certificate of essential land title, especially when the land is claimed by members of indigenous community. Essential land can be illegally recognized even without formal titles, as long as met the definition under IPRA long-term possession and occupation by indigenous people based on custom and tradition. Court can review NICP decision only if there is abuse of power or violation of due processes, but they cannot enter just because they disagree with NICP decision. So this case, this why this case is important. Affirm the power of NICP is hand central land issues, protects indigenous land rights even when claims don't have government issue land titles, so that IPRA is a strong legal basis for recognized indigenous land rights. Emphasize respect for native custom, tradition, and history in deciding land ownership. So the Supreme Court warned that essential land claim must still follow proper procedure and not to be used to bypass land laws. But legitimate indigenous claims should be respected and protected. In a simple word, indigenous people like the Bacalsos can own the land legally through essential right, even without land title, and NICP has the power to recognize that. Regular courts cannot be ignored or cancel NICP decision unless this proof of wrongdoing.
My topic is all about Republic v. Court of Appeals 2005. The case Republic v. Court of Appeals 2005 involved the recognition of a central lands and the issuance of certificates of a central domain title to indigenous communities in the Philippines. The Supreme Court decision in this case highlighted the importance of the Indigenous People Rights Act and protecting the right of indigenous people against claim made by the state. The IPRA is a legislative act that recognizes and protects the right of indigenous communities, ensuring that their ancestral lands are recognized and protected from encroachments or claims by the state or other entities. This case underscores the legal protection provided by the IPRA for indigenous communities. ensuring that their ancestral lands are safeguarded against state claims.
Next cases. Diosdado Sama and Bandimang Salay versus People of the Philippines. The court ruled that even if the land is ancestral, indigenous people can still be prosecuted if they violating environmental laws. So let's talk about this case. So it highlights the delicate balance between the rights of indigenous peoples and environmental laws in the Philippines. So let's have a summary of these events. So on March 15, 2005, Diosdado Sama and Bandi Mangsalay, along with their companion, Demetrio Mangsalay, were accused of violating Section 77 of Presidential Decree Number 705, which is Revised Forestry Code of the Philippines, because of they cutting down a data tree and they use unregistered power chainsaw in Barangay Kalangatan, San Teodoro Oriental, Mindoro. So, according to the court, the charges of the tree that they cutting, the tree yielded a total of 500 board feet. So the value of each has a 20,000 pesos. So the accused admitted that they had no permit but asserted that the act was part of their rights as Iraya Mangyan. So they defend that they have right to do that because the land is of IP. So indigenous people to utilize natural resource within their ancestral domain for a communal project. They have a reason, that's why they cutting a tree. So for the construction of a toilet facility for their community. So they have a nice project to do their community. So Barangay Captain Rolando Aceveda testified that the accused were members of the Mangyan tribe and that the tree was located within their ancestral domain. So that's why they have a right to do anything of that land, no? And then, however, there was no documentary evidence presented to prove their indigenous identity or the land status as part of their ancestral domain. So, for the Supreme Court ruling, on January 5, 2021, the Supreme Court ruled to acquit the accused due to the lack of sufficient evidence to prove a crime had been committed. So the court held that the prosecution failed to prove that the data tree was timber or part of the forest land, and also failed to establish that the accused had no right to cut the tree within their ancestral domain. So the court emphasized the need for through consideration of indigenous rights and environmental laws to ensure fair treatment for all sectors of society. So that's all about of the Diosdado Sama and Bandimang Salay versus People of the Philippines.
Let's talk about IPRA, or the Indigenous People Rights Act in the Philippines. It's a landmark law aiming to protect and empower indigenous communities in the Philippines. It's a huge undertaking striving to recognize ancestral land, support self-governance, and safeguard cultural heritage. While it achieved much, putting into practice in a constant challenge, truly making IPRA work means tackling red tape, securing enough funding, and most importantly, ensuring indigenous communities have a real voice and a power in decisions that directly impact their lives and future. So, this IPRA law or Indigenous People Rights Acts have many cases. So, first we tackle about the cases in Baguio City. So let's talk about the land rights in Baguio City. A place with a unique history, Baguio City had a special legal status for a long time, even before the Philippines was independent. This special status for a long time affect how land ownership work here. Baguio City has a significant indigenous population, primarily composed of Cordilleran tribes like Ibaloy, Kankanai, and Benguet tribes. These communities have a deep historical connection to the region, so they lived there a long time ago, or their ancestors inhabiting the area for centuries. Over time, Baguio has become a melting pot with a mix of indigenous people and migrants from other parts of the Philippines and abroad. So let's talk about the cultural practices in Baguio City. Indigenous communities in Baguio maintain strong ties to their traditions and customs, even while living in their urban environment. They often participate in tribal rituals and celebrations, preserving their cultural heritage as what we can saw or in any social medias or any news. However, migration and urbanization have also led challenges in maintaining traditional practice and identity. So let's talk about the challenges and opportunities. The indigenous people of Baguio face various challenges, including economic instability, limited their access to the social service. As we can say, their land have not yet or not the road it's hard to go there because the road is not yet civilized, or what we call that, not concreted. So, and the conflicts between tribes, the tribal wars, which were common in the past, continue to affect some communities, adding their burdens. Despite these challenges, there are efforts to promote peace and reconciliations such as declaring Baguio City as tribal war-free zone. So how about their land rights and recognitions? Indigenous people of Baguio have been actively advocating for the recognition of their ancestral land rights. A landmark case in 2024 saw the Supreme Court upholding a lower court ruling recognizing the ancestral land claim of Bugnay family. That this ancestral land claim covering the significant area in Pinsao Barangay. This decision considered the first win for ancestral claimants in the city and has implications for other indigenous communities in Baguio. So, in summary, the indigenous people of the Baguio are the vital part of the city history and culture, while they face challenges in maintaining their tradition and identity in urban setting. They continue to strive for recognition of their rights and preserving their cultural heritage. So, a group of people, let's call them the claimants, said their family had lived on a special piece of land in Baguio for generations, long before the city was even a city. They said that this land was their ancestral land, passed down through their family for hundreds of years. They believed that called IPRA law, which protect the right of the indigenous people to their ancestral land, should protect their claim. Now, IPRA law is a good law designed to help indigenous communities to keep their traditional lands, right? But Baguio's special legal status created a problem. The government argued that because of Baguio's unique history, IPRA didn't fully apply there. Why? Because they said that this special status of Baguio City, the government had already claimed the land long ago. So now the claimant went to the court to fight their land. They presented evidence to show they had lived on the land for a very long time, passing it down to their family. Now the government presented also its own evidence showing that Baguio's special status gave the government the right to the land. So the case now went all the way to the highest court in the Philippines. After a long time, the court decided in favor of the government. The court said that because Baguio's special status, the claimant could not use IPRA to claim the land. So even if they had lived for the long time, this means that even though IPRA is a good law intended to protect indigenous people or indigenous people land rights, it did not work in the situation in Baguio. It highlights how complicated land ownership can be, especially in places with long and complex history. It also shows that even with laws designed to protect people's rights, proving those rights in court can be extremely difficult. The claimant case is a reminder of the challenges of indigenous people or indigenous communities face in protecting their ancestral lands even when they have strong historical claim. It also underscores the need for the clear understanding of how law like IPRA interact with pre-existing legal frameworks and historical land claim. So what's the bottom line on this IPRA law in Baguio? It's not a simple yes or no. It's about finding that balance, respecting the past while building the future. It's about making sure everyone has a voice and a fair chance, and acknowledging that indigenous communities' stories are just as important as the city grows. It's work in progress, a journey, not destination. And how will we navigate that journey will define the Baguio's future. So next is about Ikalahan case. Imagine a community nest deep within a lush forest. Their lives intricately woven into the fabric of the land of their fourth generation, which means they lived in that land very, very long time ago. This is the Ikalahan people, and their story is a powerful illustration of Indigenous People Rights Acts (IPRA) in the Philippines. IPRA isn't not just a legal document. It's a promise, a recognition of the rights of indigenous communities like Ikalahan to their ancestral lands and their way of life. So, what are these Ikalahan people? The Ikalahan are an indigenous community in the Philippines, primarily residing in the Nueva Vizcaya and Benguet provinces, particularly in the Imugan and Cayapa areas. Their name derives from the word Kalahan, which refers to the evergreen pine trees and deciduous trees found in Carabalo Mountain. There were many of their settlement and local. The prefix I denotes people or residents, making Ikalahan means people of the forest. About the cultural practice of Ikalahan. The Ikalahan have rich cultural heritage with a household called Hampanga, Bungan, serving as the basic social economic unit. That this unit typically includes the husband, wife, their children, and elderly parents from both sides, all sharing their daily tasks. The kinship ties are bilateral or bilateral, extending beyond tradition kinship system, often including distant relatives, maintain honor and prestige. How about their social structure? Ikalahan society recognizes two classes: the rich or baknang or kadamyan, and the poor is bitig or abiting. While wealth is measured in terms of animals and land properties, it does not necessarily translate to political influence with the community. The wealthy primarily will greater influence on financial decisions. So, how they got their foods, or how they eat, or what they do about their economy? The Ikalahan are primarily engaged in wheat rice cultivations, along with growing sweet potatoes, taro, and raising pork or pigs. They practice a variant of the standard Cordillera culture, emphasizing the importance of pigs and meat sharing, as well as the pad or prestige feast. Taro is a preferred food, and rice is raised in low terraces, fields, and valley. A significant baskery industry exists in Imugan and Santa Fe area, or what we call the rice terraces. So, how about their traits and response? If we can face the Ikalahan, how they respond to us? The Ikalahan community face traits such as mining activities, that could damage their ancestral domain, which cover the mountain forest and farmland with high level of biodiversity. They have demonstrated resilience by protecting their own territory and advocating for their rights. So in summary, the Ikalahan are the vibrant, resilient indigenous group of the Philippines deeply rooted in the cultural practices and committed to preserving their ancestral domain and heritage. For the Ikalahan, their ancestral domain, the Kalahan Forest Reserve, is more than just trees and soil. It's their history, their spirituality, and their very identity. For centuries, they live in harmony in environment, practicing sustainable farming methods, but there's the outsiders came, wanting to exploit the land for profit, threatening their way of life. And then, the IPRA law in the Philippines stepped in, offering a legal shield for the Ikalahan's indigenous people. It says that indigenous communities have the rights to self-determination, the right to decide their own futures, to manage their own resources, and protect their culture. It recognized that their ancestral domains are there not just legally but fundamentally. IPRA also guarantees the rights to cultural integrity, the right to preserve their traditions and language and belief. The Ikalahan struggle culminating their legal victory and establish of the Ikalahan Educational Foundations, the KEF, that perfectly embodies IPRA's spirit. They fought for and won the right to manage their forest reserves, providing that indigenous communities aren't just passive recipients of aid, but active steward of their land and capable managers of their own resources. So the KEF isn't just an organization. It's an embodiment and their self-determinations, allowing them to chart their own course toward the sustainable futures. So IPRA is just about laws and courts. It's about how empowering indigenous peoples, communities like the Ikalahan to protect their heritage, their lands, and their futures. It's about recognizing their inherent rights and providing them with the tools to exercise those rights, ensuring a people where their voice are heard and their rights are respected. So this Ikalahan story is a powerful reminders in IPRA or the Indigenous People Rights Acts in the Philippines that the purpose is its potential to create more just and equitable society. The Ikalahan case shows us the messy reality of IPRA in the Philippines. It's a story of both hope and frustrations, highlighting the difficulties of protecting indigenous rights when other interests are involved. It's a reminder that IPRA is more than just a law. It's a promise, and making that promise real take constant effort, right? As we observe or as we experience, the clear rules and most importantly, giving indigenous communities a real voice is what happened to their land. The Ikalahan fight is a reminder of how much work still needs to be done to make IPRA law truly work for everyone it's meant to protect. And that's all. Thank you.